permission to appeal in the matter of HMRC and Burlington Loan Management DAC.
Yes, good afternoon, Mr. Benjamin Stockham.
Good afternoon, my lord. I appear with my learned friend Mr. Hellier for the appellants, who I'll refer to as HMRC. Three quick matters of housekeeping, if I just run through them. First, you should have two bundles, hopefully, a core bundle and a permission bundle. Permission bundle just has a few extra documents relating to the procedural matters addressed in the order and then the authorities. There should also be a short skeleton argument for this hearing, which hopefully you received a copy of. And then third, just as to timing, my understanding is we have an hour, but I just wanted to check that was accorded with your understanding.
Yep, exactly right.
Well, if I can start by way of short overview, given the time constraints, I'm not proposing to run through the factual background unless there is anything I could assist the court with on that. So by way of overview, HMRC's position obviously is that the appeal meets the test for a second appeal. There are real prospects of success, and the appeal raises important points of principle. I'm conscious that my lady has been required to deal with a number of main purpose appeals in the recent past, so may have a sense of deja vu here. But in my submission, this appeal does raise important points of principle that are not addressed by the recent Court of Appeal decisions in BlackRock, QuickFit and JTI. It also has the additional feature that this is, as far as we know it, the first case in the world to address a main purpose test of this kind in a double taxation treaty context. So there is genuine global interest in this appeal. In my submission, HMRC do have at least a real prospect of success, and indeed in my submission, HMRC's case is clearly correct. Now, at first sight, that may not appear to be the case. I accept the case involves a simple transaction, purchase of a debt claim at arm's length, and the instinctive reaction to the transaction may be that it's not the kind of transaction that an anti-abuse provision should apply to. However, in my submission, first impressions can be deceptive. And I'd submit for the reasons set out in HMRC's positive case, that's in the permission to appeal skeleton, the longer skeleton, paragraphs 37 to 42, this is in fact a clear case, and there should be no doubt that Article 12.5 does apply here. That's on the basis that the sole basis for the assignment of the SARD claim was, in my submission, UK withholding tax arbitrage, from which both Sickle and BLM, the two entities that were party to the transaction, were able to benefit. And, oh, yes, my lord.
I mean, the introduction of the word arbitrage seems to sort of, well, the skeleton is riddled with the word arbitrage. It doesn't have a meaning that I sort of recognise as a,
well,
as
if I could just say avoidance of UK withholding tax, and in effect the sharing of that UK withholding tax between the parties to the transaction. It's just a shorthand for saying it's the avoidance of UK withholding tax.
Well, this gets to the nub.
Well, it does to some extent, my lady, yes. Well, the question might be, was it a main purpose to avoid UK withholding tax? And in my submission...
that's not quite what the test is.
No, main purpose to take advantage of Article 12.1. Well, specifically Article 12.1.
And do you now, I think, probably accept, or at least you're not going to try and contend that Sickle had an illegitimate purpose of that type?
We are not pursuing that point, my lord. In effect, because both sides of the transaction, the core of the case is the same.
Well, is it?
Well, in my submission, yes, my lady.
It's Sickle that had the withholding, from your perspective, the Sickle had the withholding tax problem.
Indeed, my lady, it was Sickle that would have been subject to irrecoverable withholding.
It realised it could realise a greater amount in total by selling in the market.
Indeed, my lady, and BLM was expressly aware of that fact, and in my submission, that fact was the entire economic basis for the transaction. And
well, when you say the entire economic basis, I mean, Sickle is a company in liquidation whose liquidators are obliged to do what they can to get the best price reasonably obtainable for the assets under their control.
Yes, ma'am.
If you become aware that an asset under your control is potentially more valuable to others than to you, without any identification of a specific other, but you're aware that there are factors that mean that other people not having the same characteristics as you will pay more for it, then your commercial purpose has nothing to do with double tax or tax treaties or anything else. You just are doing what the law requires you to do and seek the best price in the market for the asset.
Well, there's a risk there of straying into Sickles' position, which obviously we're no longer pursuing, but it
Well,
might...
you say that you're not pursuing, but actually one of the issues is whether for your case to succeed, you have to stray into Sickles' position.
Well, my lady, in my submission, you don't need to, because the question that's posed by Article 12.5 is not, as the Upper Tribunal viewed it, was there an abuse of the treaty or was there an abuse of Article 12? The question is, was it a main purpose to take advantage of Article 12.1?
Well, I understand why you say technically that you only have to succeed in relation to one of the parties. But quite a lot of the argument seems to suggest that this was to be distinguished from a normal commercial transaction. But if it's for one party a commercial transaction because it's aimed at doing what they are under an obligation to do, i.e. to sell an asset if they can get more for it, it becomes much more difficult to then approach the other party's purpose from a sort of suggestion that they're not engaged in a commercial transaction.
Well, in my submission, my lord, I wouldn't accept that proposition, because here, well, you have my submission with the skeleton, but the sole basis on which BLM was entering into this transaction was on the basis that it would benefit from Article 12.1, and that is the only basis on which it was able to make a profit. Absent the benefit of Article 12.1, because in effect, if very simple terms, it pays 92 for something worth 100. If it doesn't benefit from Article 12.1, this is necessarily a loss-making transaction for BLM. So it's not a case.
But it's not a case. I mean, in your most recent skeleton argument at paragraph 8, you suggest, I think at the start, that that one of the FTT's errors was its failure to take into account in its reasoning that the assignment of the claim would not have occurred at all if BLM was not able to benefit. I mean, do you mean that this particular assignment wouldn't have occurred at all, or any assignment?
This particular assignment, and to be clear, it's the facts of this case and the particular characteristics of this claim. Because although BLM had acquired lots of claims in the Libby administration before, the factual circumstances relating to those acquisitions were very different. I mean, you're going back to 2011, so some of the earlier acquisitions, there was a question whether the principal would be recovered at all.
Yeah.
There were all sorts of contingencies in those earlier circumstances, where I'm sure Mark does, where Article 12.1, and again, we don't have the facts of all the earlier acquisitions, and obviously you have my submission, that was one of the errors that the FTT made in inferring something from those earlier acquisitions. But clearly the factual situation was very different there. What's different about the SARD claim, and the reason that HMRC have only taken the position that 12.5 applies in respect of the SARD claim, is by that time, the only value in that claim is the interest amount. And it's also become clear, and it's the only acquisition that happens after the Court of Appeal has decided that these are subject to withholding tax. So in those circumstances, contrary or in contrast to the earlier many acquisitions, the benefit of Article 12.1 has assumed paramount and, in my submission, sole importance. It's that provides the differential in value, as it were, between the claim in Sickles' hands and the claim in BLM's hands.
Is that no more than saying, well, it's more obvious? The same point, although the numbers might not be as obvious, would have been in play at earlier stages. Sickle or its equivalent would have been subject to irrecoverable withholding tax, and some buyers would not suffer withholding tax or not as an absolute cost.
Well, my lady, my submission, there are qualitative differences because of the other contingencies. Now, for example, if you're having a debate about whether you're going to recover 7 pence on the pound of the principal or 100 pence on the pound or whatever, then all of a sudden that is a much bigger consideration. And that's nothing to do with the benefit of Article 12.1.
But picking up the point that my lady made to you earlier, let's assume that after the Court of Appeal decision, the liquidators of Sickle sit down and they say, crikey, well, we're going to have to pay withholding tax. How do we fulfill our duties as liquidators? Well, actually, there will be others out there who aren't positioned like us. we can get a better price for selling this asset to one of those people, whoever they may be. We don't care where they are. We don't know, what might mean that they're in a better position. Tax might be one such factor. There may be others, but we at least ought to test the market. Are you saying that was taking advantage of Article 12 by the sickle liquidators? And if you're not,
Well, we were saying that.
how can you? Yeah, but you're not proposing to do so now, and so how can you sort of not advance that case in relation to them, but advance it in relation to BLM?
Because in my submission, it is still BLM. BLM are still taking advantage, or their main purpose is to take advantage or obtain the benefit of 12.1. From BLM's perspective, this is a transaction where they have paid 92 on the express basis that they are going to recover the withholding tax. And in my submission, that is the only reason they have bought it, because they can realise a profit, but that profit is entirely a function of the tax benefit. And so from BLM's perspective, their main purpose of being concerned in the assignment is to benefit from 12.1.
The profit arises from the fact that they pay less for it than they expect to receive from it.
But what they're receiving is 20 of it is a function entirely of being able to benefit from 12.1. They would only receive that 20 if they can benefit from 12.1. Yeah. And in my submission, that is entirely what the transaction is predicated on. So
what distinguishes this transaction from any other transaction in which somebody in Ireland, for example, buys an asset, an income-generating asset in England?
It would have, for the specific purposes we're looking at, obviously it would have to be interest, because we're talking about withholding tax on interest. But what distinguishes it from the other claims in the levy administration, for example?
But interest is not an uncommon feature of loans and everything else.
No, indeed. The question that in my submission the tribunal should have asked is, well, what was the basis of the transaction? Is there a commercial basis for the transaction, or is it entirely based on the tax benefit?
Well, for sickle, it is entirely commercial in a sense that that's what liquidators do. Their whole raison d'etre is to sell, and that's a commercial transaction.
Well, but I mean, without wishing to, I'm looking at BLM's position here.
Yes, but the point being made is, yes, you are looking at BLM's position and you're not pursuing ground 4, but you're still trying to impugn the transaction as entirely, I was going to say tax motivated. I'm using motive in the shorthand, you know what I mean. You're trying to impugn it as entirely tax motivated, but
absolutely.
But Sickle's decision to sell is quite patently a responsible decision of liquidators who need to realise the best price, or the best that they can reasonably realise for the asset. So you are effectively saying that they did the wrong thing in selling.
Technically, not really, my lady, because what we're saying is that it's BLM will be denied the benefit of Article 12.1. The point is, to put it crudely, is that Article 12.1 is about saying taxpayers based in Ireland don't have to pay the UK withholding tax, to use the specific facts in this case. What we're saying 12.5 does is to say you can buy debt into the treaty protection if you're doing it for actual commercial purposes. But if your main purpose of buying the debt within the protection of the treaty is simply to benefit from Article 12.1, then Article 12.5 knocks that out. And the point is, Article 12.5 isn't a penal provision, and I think I said in the Upper Tribunal, it's not casting some moral aspersions on anyone. It's simply saying that if you do a transaction where the main purpose is to benefit from 12.1, and here in my submission that was the only purpose, then you don't get the benefit of 12.1.
But we know, I'm just trying to understand what the consequences of this be. You say the main purpose, but I think the treaty says the main purpose, one of the main purposes. That may be anything more than might be anything more than icing on the cake, to use a term.
Well,
that's
we know
been
it needs to be
used.
more than that.
That's been, yes, but could be anything more than that. It's certainly very different from the main purpose.
Absolutely.
So one of the issues is how far this argument logically takes you. It's all very well to say that this is a much clearer case than the earlier purchases where there were lots of other things going on and other contingencies. But the underlying point would still have been there, that BLM would have recognised that any withholding tax that did arise would not be a cost for it.
Well, for all the other acquisitions, of course, Melody, there wasn't a decision to the effect that these claims were subject to withholding.
It was known
tax.
to be in dispute for a long period.
It was, and then there was a High Court decision saying that they weren't subject to withholding
Yes.
tax. So this is the only acquisition that happens after you have a Court of Appeal decision specifically saying that these claims are subject to withholding tax, and that's another part of the particular features of this claim. It's a pure interest stream.
But there are many things that are just a pure interest stream that are generated in the UK. Are you saying that no Irish-based entity can buy those assets? Because you're going to say in relation to all of those transactions, well, the reason that they are looking to buy the assets is because they're in a more favourable position as regards withholding tax than the person who is receiving income in the UK.
Well, one would need to obviously look at the particular circumstances of each acquisition. My submission, it's certainly not the case that it would apply in every case by any means.
But how would it differ? I mean, I understand why this is potentially, a very important point, which may be that you don't need to worry too much about whether this appeal would raise an important point of principle. But I'm just, it's said against you, I think, that if you were right, this would have a major effect in the bond markets or in the markets. I mean, I can see that, and in fact, much more broadly. So where do you draw the line?
Well, to take one example, my lord, I mean, we obviously here have an acquisition from the Cayman Islands, which doesn't benefit from an equivalent to Article 12.1. If it was an acquisition from another territory which did have an equivalent to Article 12.1, then plainly the purpose of benefiting from Article 12.1 would not be the main purpose, because the position would be exactly the same. What's not peculiar, but what is particular about this case is that the debt is situated initially, or is held by an entity that doesn't benefit from an equivalent to Article 12.1, and it's being bought into, in effect, the treaty protection in Article 12.1 in Ireland. So, yes, it would potentially require purchasers to say, well, who is my counterparty? Where am I buying it from? Is the only or the main reason that I'm doing this transaction to benefit from the tax benefit of Article 12.1? Now, I accept that may have some impact on the debt market, but in my submission, A, it's not a very significant impact. I mean, clearly there's no evidence as to how significant or what effect it would have. But in effect, it would simply require a purchaser to say, well, who am I buying it from? Is the main or the sole basis, as in my submission it is here, that I'm doing this transaction to benefit from withholding tax exemption? And if it is, then 12.5 applies. And just to take the point further, in my submission, that is a perfectly coherent position for both Ireland and the UK to have adopted. Because in HMRC's analysis would apply in the mirror case. So if an English entity bought a debt from a Cayman entity that would have been subject to Irish withholding tax, and the sole economic basis for it doing it was to get that exemption, the same would apply.
Well, I understand that, but I do repeat that the treaty doesn't just apply if it's sole, it's a
My lady, I accept that.
It's very easy to provide extreme examples, and effectively you say this is. But that doesn't answer the question of law.
My lady, I of course accept that main purpose tests do involve hard cases on the margin. I mean, I think that's inevitable, as one sees in the unallowable purpose context. But in my submission, this is an extreme case, because as I've submitted, the only basis is the tax benefit. There is nothing beyond that.
We should let you develop your.
I fear we may have already addressed most of the things I wanted to say. But you have my submission that here the arbitrage or the avoidance It is entirely based on BLM's assumed ability to benefit from 12.1. And as I've just submitted, it's an entirely intelligible and sensible and reasonable purpose for the contracting states, or to impute to the contracting states that they wanted to seek to prevent this kind of withholding tax arbitrage. You have my submission, it applies both to protect the Irish and the UK revenues. I've submitted already, Article 12.5 isn't a penal provision, it simply switches off a tax benefit that would otherwise arise under the treaty. And another point to note, and perhaps it addresses your question about bona fide commercial transactions, the earlier version of Article 12.5, as you may have seen from the skeleton, did have a carve-out for those kinds of transactions. Article 12.5 doesn't. It's simply a question of, was the main purpose to take advantage, or, in my submission, to obtain the benefit of Article 12.1. So briefly, I was proposing to take things in three parts. First, just to make brief submissions on each ground of appeal, then talk about an important point of principle, and then just address the procedural questions if those are something I need to address you on further. So briefly, the submissions in respect of each ground. By way of introduction, I fully recognise that the appeal is concerned with a challenge to an evaluative finding of fact by the FTT, so it's finding as to main purpose. But in my submission, grounds 2 and 3 are not simply a sort of classic Edwards and Bairstow challenge to that finding. They do engage directly with the reasoning on the face of the First Tier Tribunal's decision. And the court will have seen the passage in the lifestyle equities case, the Supreme Court decision. I don't know if it would be useful to go to that, or whether you've already seen it, have read it, of course. But in my submission there, the Supreme Court draws a key distinction between issues and questions that simply involve a question of degree. Was the conduct negligent? That's in paragraph 47. Contrast that with cases where there are, as the court says, identifiable flaws in the judge's treatment of the question to be decided, which undermine the cogency of the conclusion. And that's paragraph 49. Supreme Court then lists, or gives a non-exhaustive list of examples, such as a gap in logic, a lack of consistency, or a failure to take into account some material factor. Now, it's notable in that lifestyle equities decision, the Supreme Court expressly recognised that the first instance judge got the relevant law right. But nonetheless, the Supreme Court was prepared to engage in a pretty detailed factual analysis of the Amazon website, and then to set aside a finding of fact made by the High Court on the basis of, quote, a multifactorial assessment of all the relevant circumstances. And that's paragraph 28. Now, there's no such detailed factual analysis required in this case. My submission, what HMRC are seeking to do is to identify clear material errors in the reasoning of the First Tier Tribunal on the face of the decision. Now, my submission, ground 2, involves, in the Supreme Court's terms, a significant error of principle in applying Article 12.5. And grounds 2 and 3 both identify other errors in the reasoning that undermine the cogencies of the First Tier Tribunal's conclusion.
And those both relate to BLM.
But both to BLM, yes.
So, do you, if you're not pursuing ground 4, which relates to sickle, you're content, are you, that you're stuck with everything that the FTT and the UT said in relation to sickle?
I think that must logically follow, my lord, yes. In my submission, each error that I've...
Sorry, just pausing.
Yes, my lord.
I understand your individual errors, the points you identify in ground 3, points you identify. In relation to ground 2, you're challenging the FTT's decision that BML's purpose was to make a profit.
Sole purpose.
But the way in which you do that really keeps going back to Sickle's wish to sell, because you're contrasting Sickle being in a position where it's subject to withholding tax with BML's position where it is not.
My lady, I wouldn't accept that. I do. There is a part in the FTT's decision where it says, well, we must have, to some extent, been focusing on Sickle's position when we're involved in the analysis of BML, and says I was very keen to stress that BML knew that Sickle was subject to withholding tax. The reason I was keen to stress that was because it showed that BLM was expressly aware of the fact that it was able to buy this debt for 92, or this claim for 92, purely because of the withholding tax position of Sickle. So when you're looking at the purpose or object of BLM, you can say, from its perspective, what it's getting from the transaction, the profit is entirely a function of its ability to benefit from Article 12.1, but also BLM expressly knows that Sickle isn't able to benefit in that way. And so that there's no way in which Sickle can be said not to have been proceeding on the basis that it was going to profit from its assumed ability to benefit from Article 12.1. And you have my submission, that is the sole basis of this transaction. So it's not necessary to contrast Sickle and BLM's position. One is simply saying, looked at from BLM's perspective, and perhaps to adopt something that was said in Blackrock, why is this transaction being done? Well, yes, in a broad sense, it is for BLM to make a profit. But that profit is entirely dependent on and a function of.
But why is this transaction being done is because Sickle's liquidators can see that there's a price out there in the market that's greater than 80. Only one of the potential purchasers is BML. There are lots of others who may not be subject to withholding tax for all sorts of reasons, nothing to do with Ireland.
Well,
BML happens to offer the best price.
to take that in two ways, Melody. One is, these hypothetical other purchasers, one would have to ask, is the reason that they are able to benefit from an exemption from withholding tax subject to a similar provision to 12.5? Now, if they're in a treaty state similar to Ireland, then the same argument would run. There are other entities for which different regimes would apply, but in each case you have to ask the question, and we're obviously not concerned with that here, if you've got a UK corporate entity, is there a main purpose provision or some other provision that says, no, you can't buy this debt in this way and obtain the benefit of an exemption? Now, the point is we should be focused on the actual transaction here, which is a purchase by an entity that assumed it had the benefit of 12.1, but where that benefit is expressly subject to a main purpose test.
Okay, so you've referred there to grounds 2 and 3.
Yes, my lady. I was going to start by saying, in respect of ground 1, that, as you've seen from my skeleton argument, is solely concerned with the Upper Tribunal decision. Now, the Upper Tribunal did take a different approach to the construction and application of Article 12 to that taken by the FTT, and you've seen the two related errors of law that we've identified in respect to that decision. My submission, those are unquestionably pure errors of law. They go to the construction and application of Article 12.5.
Yes, can we just, you're going to make submissions on those two elements?
Well, I mean, they're set out in the skeleton.
Just on those.
Yes, my lady.
The first is the reference to abuse, which you say is
Yes, my lady.
addressed. But is that an entirely fair description of the UT decision? Among other things, they say it was agreed that it was an anti-abuse provision.
And it is agreed.
And the sole meaning is what abuse meant in that context.
Indeed, my lady, but my submission, what the Upper Tribunal did wrong, and it is, I should confirm, it's always been common ground that it's an anti-abuse provision. HMRC's position is that what that abuse is that there will be an abuse of the treaty if you here acquire debt with a main purpose of obtaining the benefit of 12.1. That is the specific abuse that it is targeted at. In my submission, what the Upper Tribunal did was to say, in effect, it's an anti-abuse provision. And what you then do is look at the transaction and in some, and this is my submission, unarticulated way to say, is that an abusive transaction? Well, they don't actually answer the question. One can read the decision backwards and forwards, and I have, what they mean by an abuse. They say, was it an abusive transaction? And then they say, well, look at the result here. You've got an Irish company that's bought a claim, it's benefiting from Article 12.1, is that an abuse? And in my submission, that is not the correct way to apply the provision. The correct way to apply the provision is to look at the transaction and say, was it a main purpose of BLM acquiring this claim to obtain the benefit of Article 12.1?
Yeah. As I understand it, they were looking correctly at the treaty in the light of, among other things, OECD commentary.
Well, a couple of things about that. First, again, as I say, it's common ground that it's an anti-abuse provision, but it's not then enough to simply say, well, it's anti-abuse, therefore let's just stand back and say, is this an abuse? Because that is, I mean, that really is an undefined, and I mean, it's really a sort of stick your finger up in the air and say, is this the kind of thing that's abusive? In terms of the OECD commentary, they do look extensively at the commentary. They also look at the conduit report, which you have, I mean, it's in the grounds bill. My submission, not really relevant, because yes, conduit companies are one way of abusing Article 12.1, but the Upper Tribunal itself recognises it's just an example.
Yeah, but it is a paradigm.
It is a paradigm, but it's not exhaustive, my lady.
Indeed.
And in terms of the actual OECD commentary, the one thing the Upper Tribunal doesn't do, remarkably, is set out the one piece of the commentary that actually explains what provisions of the kind, the exact wording of Article 12.5 are intended to do. So it's paragraph 21.4 of the OECD commentary specifically relates to provisions of the kind we are concerned with, and explains that they are to do with where the main purpose is, importantly, to obtain the benefit of 12.1. And that was in part where we were in the FTT submitting that's what take advantage means. It's not about artificial transactions, it's simply about having a main purpose of obtaining the benefit of 12.1. Upper Tribunal didn't even, I mean, it didn't quote that provision, it refers to it as an example of the kind of thing that contracting parties can do. But actually that paragraph is the one paragraph where the OECD explains what this type of provision means.
I mean, if I was to put it in very layman-ish type terms, which in this area I'm probably not far from being, you'd say that the reason to have ground one in live on an appeal would be for you to be able to persuade the Court of Appeal that it's actually the wrong area to explore if you're a tribunal, to get sucked into the question of abuse and what's an abuse. It's not there on the face of the treaty. You should just look at the words of the treaty and don't get suckered into esoteric debates about what type of abuse we're talking about.
In a general abstract sense, yes, absolutely. The abuse is defined by the language of Article 12.5.
Yeah,
And
it would be better, I think, in essence, you're saying, your ground one is, would you please tell everybody don't get led astray by trying to read words into the statute that aren't there and worry yourself about what might or might not be an abuse?
Well, my lord, yes, it's two things. One is, it is just important as a general matter that the Upper Tribunal's analysis, which in my submission is wrong, is not read as being a correct analysis of how these types of provisions work.
Yeah.
So yes, apply the wording. But it's also, I mean, and it could be said, and my lady's order suggested, well, isn't that just an academic point? And we don't normally give permission for academic points. In my submission, the reason more specifically for this appeal that it's important is, when one looks at the Upper Tribunal decision, what the Upper Tribunal does is to look at the FTT's decision and say, well, they found this, but they couldn't identify an abuse, and so they were fine to conclude on that basis. And the reason it's important that we see that analysis in general is shown to be wrong, but once it is shown to be wrong, it falls away as a basis for upholding the FTT's decision, which is what the Upper Tribunal sought to do. It sought really to bolster the FTT's conclusion with its own analysis.
And in a sense, what you're trying to do by raising this kind of appeal is to say that in a circumstance where you're going to have to concede, because you're not running ground four, that Sickle had a legitimate commercial purpose in what it was doing, that your life is much more difficult if the relevant question that a tribunal has to ask itself is whether there's an abuse, because you've then got a situation where it would have to come to a conclusion that one party to a transaction had a legitimate commercial purpose and the other one was an abuse.
I'm not sure I would concede it is a much more difficult. My submission is just the wrong way to analyse the provision.
Okay, but I can see why you'd want to have it live.
But you have to ask the question: was BLM's main purpose to obtain the benefit of 12.1? That is the test posed by 12.5. And just to make good the point about the Upper Tribunal sort of using its own analysis to bolster the first tier tribunal, could I just ask you just quickly to turn up the Upper Tribunal decision? If you go to page 68, and you see in paragraph 6, so sorry, core bundle, my lord, paragraph 69, you see there, but the question before the FTT is, as we've explained above, directed at determining whether there has, by means of the particular transaction concerned, been an abuse of the UK-Ireland Treaty. So that's really what it said the FTT should be asking. And then when we go through the Upper Tribunal's decision in respect of each ground of appeal, and the numbering slips slightly because the Upper Tribunal treated ground 1 as really being the question of Sickles' knowledge, and it sort of wrapped up its analysis of the treaty in that question. But if we go to page 71 first, so 2 pages on, you see first of all in paragraph 79, and this is specifically in the context of Sickle, but in determining whether Sickle had a main purpose of improperly taking advantage of the UK-Ireland Treaty, well, that's simply not the test. They've just read the word improperly into the...
No, you're just illustrating the point I was trying to put to you, but I think very badly, that if you start defining the question you're answering by reference to words like improperly or abuse or whatever, you say you just are not approaching it in the way that you should, given
Indeed.
the express words of the treaty.
Indeed. And but it's also that second element, because my lady's order again says, well, isn't the real question here, like in dolphin drilling, did the FTT get it wrong? And if the FTT got it wrong, then the Upper Tribunal, by endorsing the FTT's decision, also got it wrong. I fully accept that it should be enough in principle for us to show the FTT got it wrong. But this case is different to dolphin drilling to the extent that here the Upper Tribunal did analyse the provision differently and then used that analysis to bolster its conclusion upholding the FTT's decision. So we can't simply ignore the Upper Tribunal's decision as one could in dolphin drilling, partly because we need the correct construction of Article 12.5 to be found, but more importantly, because, as I say, once the Upper Tribunal's analysis falls away, then the way in which it upheld the FTT's decision it is shown to not be effective. So in effect, the sort of supporting buttresses fall away and the weak foundations of the First Tribunal's finding are left bare. So it's not a purely academic exercise in my submission. Importantly also, it shows that this court shouldn't be upholding the FTT's decision on the basis that the Upper Tribunal did as well. Because if you say the Upper Tribunal got it wrong, you are then interrogating the First Tribunal's analysis, and that reason for upholding it falls away. So that's ground 1. My submission it's an important point and not academic. Ground 2, the permission skeleton for this hearing seeks to articulate the 2 related aspects of ground 2. We've sought to tease those out a bit more expressly than perhaps they are in the longer permission skeleton argument. But both aspects challenged the FTT's key findings that BLM's sole purpose in acquiring the SARD claim was to realise a profit, and its related finding that BLM's assumed ability to benefit from Article 12.1 was simply the setting for the transaction. Those are the words the FTT used. So the first element of ground 2 is my submission that the FTT analysis involves a significant error of principle, going back to the Supreme Court's language in the lifestyle equities case. And that error is that its finding that BLM's sole purpose was to, as it said, realise a profit, is in my submission not a proper or complete answer to the question that is posed by Article 12.5. And the reason for that is the sole purpose of making a profit is entirely compatible with BLM also having a main purpose of obtaining the tax benefit, here the benefit of Article 12.1. Those 2 purposes can and often do coexist in tax-motivated transactions. And here you have my submission, the profit, as it often is a consequence sought as a result of obtaining the tax benefit. Now, in virtually all tax-motivated transactions, the taxpayer will have a purpose of realising a profit or obtaining some sort of financial advantage. In my submission, as a matter of principle, it's not possible to avoid the application of a main purpose test simply by saying, no, my main purpose was to make a profit, or my only purpose was to make a profit. because that would render such anti-abuse provisions completely ineffective. Now, you can test that proposition by, if we take the example that both the FTT and the Upper Tribunal seem to accept would fall within 12.5, where you have a classic conduit company case, so Sickle incorporates an entity in Ireland, and then we do the same transaction. But it seems to be accepted that would fall within 12.5. But in that case, you could equally say that the sole purpose of the special purpose vehicle incorporated in Ireland, its sole purpose was to make a profit. But if you can give the same answer to that case and this case, in my submission, it cannot be a relevant answer or a complete answer, at least, to the question posed by Article 12.5. As we say in our skeleton for this hearing, it's necessary for the tribunal to go further and consider the basis on which BLM was seeking to realise a profit. And it's that context in which the Court of Appeal analysis in Fisher is relevant and, in my submission, strongly supportive of HMRC's case. Now, I'm conscious my lady will, I'm sure, be familiar with it, but if I could ask you just to turn it up, and my lord may well be as well.
No, perhaps for my benefit, we will tell a look.
Permission bundle, tab 10, page 115. Now, I entirely accept that this is in a different context. It's in the Transfer of Assets Abroad Code. It's to do with avoiding betting duty. And a business was trying.
An FTT finding.
We did. There was an FTT. Indeed, my lady. Yes. But my lord, just to give a very brief summary: assets transferred from the UK, or business transferred from UK to Gibraltar, to avoid betting duty, or the effect was to avoid betting duty. Taxpayer says, well, there is a motive defence to the transfer of assets abroad regime, which basically says, was the main purpose to avoid tax? Taxpayer says, no, main purpose was to save the business. And it's in the Court of Appeal decision accepted that yes, it was necessary to do it to actually save the business. It's in that context, and my lady is absolutely right, that the First Tribunal held, no, that can't be an answer, because saving the business is purely a function of avoiding the betting duty, avoid getting the tax benefit. It's in that context that paragraph 91 of the Court of Appeal decision is, in my submission, relevant. And if I could just ask the court to read it, it's page 115.
This is all said in the context of, if you like, in simplistic terms, of a one controlling mind transaction.
Yes.
Very different from the current situation where you're going to be accepting that Sickle was independently minded and had a different commercial purpose.
That is a distinction, but in my submission, it's not relevant to the principle that's articulated in that paragraph. Because if we look at the first three sentences of that paragraph, those are specific to the facts of this case. If we go from put slightly differently, there can be no question of section 741 of ICTA, which is the motive test, motive defence applying, because a transferor hopes that an intended avoidance of liability to taxation will achieve some further end. It will rarely, if ever, be the case that a transferor wishes to avoid liability to tax for the sake of it. In normal circumstances, a transferor will be intending to use the avoidance of tax to attain another object. That being so, were someone able to escape section 739 by looking beyond the tax avoidance to its consequences, the motive defence would, as the FTT pointed out, be generally available. That cannot have been Parliament's intention. Now, I accept that it's in a different legislative code. And to some extent, in my submission, the submission I'm making should be obvious. It shouldn't really need authority. But the point that one can't simply say, I avoid this main purpose test because my main purpose isn't to obtain a tax benefit, it's to make a profit, that in principle cannot be an answer to that question, because if it's right, it would always be an answer.
You seem to accept that Sickle can, because, I mean, from Sickle's point of view, they want to make a profit from selling this stream of receivables. And the reason that you say that they can do so is because they can sell it to somebody who won't suffer the withholding tax. So, you know, I come back to this real question mark about whether, you know, by not proceeding, you want to, you're trying to put aside ground 4. So I just,
Well,
And-
mainly to sort of reduce the number of issues, frankly. Well, but I mean, it's accepted. It's been common ground throughout that it's only necessary to show that one party is the main
but
purpose.
that I understand. But
And there's nothing, and we know that there's no longer a bona fide commercial transaction claw out. And in my submission, very plainly, be it purely from BLM's perspective, this transaction is a transaction that is based solely on obtaining the benefit of Article 12.1. And the test requires you to ask, was it a main purpose to obtain the benefit of Article 12.1?
Anyway, we're not here to decide this case, but to
No, my
decide
lord,
whether
but-
you've got a chance at running that
Indeed, my lord. of
with
course.
a, you know, realistic prospect of
I'm not gonna
success.
hope for half a day to be able to persuade you that that's right. But in my submission, when one applies the actual test in the treaty and doesn't just do what the Upper Tribunal did and stand back and say, well, is this abusive? Is this the kind of thing? Then
So,
it's,
okay, so just on ground 2,
Yes.
we're just moving things along a little bit.
yes, of course.
We should. Footnote 4.
Motive.
Last sentence.
Sorry, my lord, you know my skeleton better than I do.
Sorry,
I can't remember which is the footnote.
The short one for this hearing. Paragraph 8, footnote 4, page 4.
Climate Benson.
Yes.
Yes, Cross J's remarks were obiter, but you'd need to think about the impact of Cross's on this, what you say here, by the way.
Absolutely. Could I come on to address
But can you deal with my lord's question?
Well, the last sentence you say BLM could only be said to be a commercial transaction if BLM was entitled to the specific tax benefit and that tax benefit was expressly subject to a main purpose anti-avoidance rule. I mean, it comes back to this point. You're trying to say that it's not a commercial transaction. You're contrasting a commercial transaction and a non-commercial transaction. You're saying it's not a commercial transaction. Is that right for BLM?
From BLM's perspective, no. Well,
But you're going to be accepting that it was from Sickles' point of view. So is this right? Your interpretation of the way this treaty works is that you've got a sort of transaction that from one perspective is commercial and the other transaction isn't.
there is, I need to go back to the FTT decision as to whether there is a specific finding that it is commercial from Sickles' perspective. We are not seeking.
I think you are going to have to accept that because, unless I miss it, you're going to have to redo your skeleton argument on any view, but in your main skeleton argument, I think you came extremely close, if not to doing that in paragraph 27. I accept you don't. I accept you don't have an express finding, but is that
Well, my lord, I would certainly say we are obviously, if we proceed on that basis, accepting that 12.5 doesn't apply to Sickle. I think we have to, or in respect of Sickle. I think that must follow from us not pursuing that ground.
yeah? One of your previous grounds for attempting to attack Sickle. Anyway, okay, well, all right. I probably laboured that point too much, but anyway.
No, but in terms of the footnote, what we're saying is the point that we've already made, that you can only view it as commercial from BLM's perspective if they are able to benefit from 12.1, and the commerciality is entirely a function of the benefit of 12.1. So in terms of ground 2, just to, I'm very conscious of time, I've not quite made the progress I'd hoped. That first point of principle, whether or not saying a sole purpose of profit is an answer to the question, is one aspect of it. The other second aspect of it is that on the specific facts of this case, and I've already really addressed you on this, the profit is entirely dependent on and attributable to BLM's assumed ability to benefit from 12.1. And you have my submission, it's otherwise necessarily a loss-making transaction for BLM, And perhaps the simplest statement of that is at paragraph 27 of the Upper Tribunal decision. If I can find it quickly. Yeah, a further consequence of the FTT's finding is that BLM would have realised it could only make a profit on the transaction if it obtained the benefit of Article 12.1 of the treaty. And moreover, we have the fact that the FTT found that the reason why both parties, but for our purposes BLM, viewed the SARD claim as having a different value in the hands of Sickle and in the hands of BLM was attributable to the UK withholding tax treatment of the two parties. Now, in my submission, in those circumstances, it is not conceptually possible to dissociate BLM's purpose of making a profit from its purpose of obtaining the benefit of Article 12.1. Those two purposes necessarily go together. And it's not even a case of saying they're two sides of the same coin. It's quite an easy sort of aphorism to fall back on. But here, actually, the profit is a consequence of and dependent on the tax benefit. So the tax benefit is the prior thing. Further, this is not a case like BlackRock or many other cases of main purpose, where you've got some commercial purpose and some tax purpose, and to some extent one is engaged in weighing those two purposes. Here we have BLM's sole purpose, just to adopt the FTT's terminology, to realise a profit by obtaining the benefit of Article 12.1. So in my submission, it follows from the FTT's finding as to sole purpose that obtaining the benefit of Article 12.1 must be a main purpose. And in that context, the FTT's finding that Article 12.1 was only the setting for the transaction is, in my submission, plainly wrong. Article 12.1 was the sole basis for the assignment to take place. And in lots of cases, you have to infer that from the economics. You can sort of say, well, look at how the transaction works. That getting the deduction must have been the reason for the transaction. Here you have not only the economics of the transaction, which in my submission are entirely clear, but you also have the contemporaneous emails that were sent from the BLM team, technically the DKCM team, saying the reason we were able to buy this for 92 was because Sickle has a withholding tax problem. And just to give you the references for that, it's core bundle tab 8. It's pages 112 and 114. There's an email from Mrs. Gibbons, who was the witness, and who was the person really deciding on behalf of BLM to do the investment. Page 112. It's in the FTT's summary of all the documents, paragraph 79, subparagraph 11. An email from Ms. Gibbons to Mr. Swartz, looping and gave, I believe he discussed with them last week, this is being sold for withholding tax reasons. And then 2 pages on.
That you will be accepting, you're not challenging.
That it's being sold for withholding tax reasons. No. I'm positively relying on it, my lord. And then in subparagraph 21, 2 pages on, this was a further email after the transaction from Ms. Gibbons. We purchased Sickle's Libby claim at an attractive price since they had a withholding tax issue. So it's not just the economics of the transaction, it's also BLM's expressed sentiment at the time that it was the withholding tax, it was the withholding tax that was the transaction.
Yes, but that's just saying 21. I mean, isn't that just saying the price we offered was attractive to Libby because they had a withholding tax problem?
So we were able to buy it at an attractive price because they had a withholding tax problem. So that is the reason we are able to acquire this and make a profit. It's all about the withholding tax.
But
in circumstances where BLM knew that it could benefit from Article 12.1. So it goes to the point, my lord, that one doesn't just need to look at the economics to see that the whole raison d'etre for the transaction was the withholding tax differential. It's not just the economics. There's also contemporaneous documents saying that's how we are able to do this transaction and make.
You're saying the word attack. You're saying the reference there to an attractive price is what attractive to BLM.
Yes.
Normal use of that language, is it?
Well, they're paying 92 for.
Yes, but it's attractive to that we were able to buy because what we offered was attractive to the seller because they had a withholding tax. But anyway,
Well,
okay, all right.
okay.
Anyway, right. I'm not sure that's your
I've already touched on the point
strongest
that,
point, shall we say?
that importantly, HMRC's analysis doesn't entail that Article 12.5 would apply to all debt assignments. And you have my submissions that it's the particular circumstances of this case, which we've already touched on. And it's in those particular circumstances. So the only value is the interest. You now have a decision of a senior court saying that these claims are subject to withholding tax, and the counterparty can't benefit from an equivalent benefit. That means the benefit of Article 12.1 assumes that importance. Quickly to address then the Climate-Benson dictum, which was my lady touched on in the order. It notes there is some similarity between that case and this. In my submission, Mr. Justice Cross's remarks don't tell against HMRC's application for permission. Obviously, it's the High Court. It's obviously not binding.
No,
It's
but my point
dictum.
is carefully considered, not only in senior but now in Quickford.
Indeed, my lady. But I mean, 2 points I'd make. First point, and I know this in passing, this isn't the main point, but in passing, my submission, Mr. Justice Cross's analysis there is flawed at best. Because you'll recall the example he gives of saying trader buys for 20, sells for 30, and says abusive language to say getting the deduction for the 20 would be a main purpose. Now, not clear at all from that example that the profit resulting from the transaction is entirely dependent on getting the tax benefit, which was the case in Climate-Benson and is the case here. So just first point, in my submission, not clear at all that Mr. Justice Cross's analysis is correct. But more importantly, and in any event, as my lady knows, all the senior courts have said, well, you have to read those comments in the context of that particular transaction. And the relevant context in that transaction was that the tax benefit in question in Climate-Benson, so in effect being able to exclude taxed interest from your P&L account, was specifically permitted by the UK tax code, as my lady noted in paragraph 86 of Quickford. And that tax benefit was not expressly made subject to any main purpose test. It was just a general rule of the UK tax code that you could exclude taxed interest or taxed dividends from your P&L account. Contrast with, well, FS Security.
Okay, we'll not go there, but I think if we grant permission, you're going to have to go a bit further than that.
Well, FS Security said that it's just a general rule. You're not relying on any particular legislation.
Yes, but the context of Climate-Benson's the transactions and security.
Well, of that particular appeal.
Yes, but did precisely attack bond washing, which was what this was all about. So you would need to go quite. I don't want to take up time now, but you would need to go quite a bit further.
Well, one thing I would say, my lady, is Mr. Justice Cross did specifically advert to the fact that Parliament could have sought to deny the particular benefit that traders and charities had. He said, well, you could imagine, you know, the revenue going on, getting Parliament to enact something that denied this benefit. But in my submission, that's exactly what the contracting parties have done in this case by including Article 12.5 in Article 12. So the benefit that we are looking at here is expressly subject.
But we need to think about the transaction and security.
I think about it every day. The final point, just to note, again, a footnote point, is the point about motive and purpose. Now, it is, you've seen the passage as a reason, they define, or the FTT defines a purpose as a reason for doing something. Now, it's a short bit of text in the decision. I'm not seeking to put all the weight of the appeal on it. But in my submission, it does give at least a hint of a confusion of motive and purpose. And if that's right, it would, in my submission, explain the tribunal's conclusion, but also constitute a further error of law in that decision. Because in equating a purpose in doing something with a reason for doing something, that certainly is redolent of a confusion in my submission of purpose and motive. Because if by reason for doing something, the FTT meant a motivating reason for doing something, that would explain its conclusion. Because you can coherently say that BLM's motive in acquiring the SARD claim was not to obtain the benefit of Article 12.1, but instead to make a profit, on the basis that BLM was driven by wanting to make a profit and didn't care how it made the profit. But if that was the tribunal's reasoning, then that does not entail that it was not BLM's purpose or object to obtain the benefit of Article 12.1, if that was the only way that BLM could realise a profit from the assignment. And you have my submission, it was. So if there is that confusion of motive and purpose, which that sentence, and it is right at the beginning of the FTT's analysis, does seem to suggest, that would be a further basis on which the court could hold that the FTT had made an error. I'm very conscious of the time. Ground 3, I don't want to spend a great deal of time on.
If you don't get permission on ground 2, could you sensibly believe you could get ground 3 on its own? I struggle with that.
I think you could, but it would be much more difficult.
Yeah.
What I would say is ground 3 takes up, if you sort of go through the FTT decision, the errors in ground 3 knock out an awful lot of the FTT's reasoning. And one could come to the conclusion in my submission that the cumulative effect of one or more of those errors is such as to render the FTT's decision unsafe. I fully accept, my lord, that ground 2 is the primary ground. I fully accept that.
And I think what you'd say is if we grant permission, if we're prepared to grant permission on ground 2, we shouldn't curtail your reliance on ground 3 because it just might be the way the argument went. It became.
And it does go to show in my submission that there are very clear errors in the decision of the FTT. I mean, the clearest is where it says, well, HMRC accepted that 12.5 didn't apply to the 442 earlier purchases. Okay. They must logically accept that it didn't apply to this. Now, that is just nonsense in my submission.
So ground 4, you're not pursuing.
Ground 4, not pursuing.
Ground 5?
Ground 5 is just a pure Oberst and Bairstow challenge.
Well, yes, but I struggle to see why it warrants permission.
Well, again,
you're seeking to identify errors under grounds 1, 2, and 3. You make no separate submissions on ground 5. Seems to me you either going to succeed on ground 1, 2, and or 3, or you're not.
My lady, if the court were to say we get permission on grounds 1, 2, and 3, and not 5, I would accept that. Of course, I would have to accept it, but that would not cause, wouldn't cause any sleepless nights. Equally, as I said in the skeleton argument, it's there for completeness. There is conceptually a possibility that you might take the view that the cumulative effect of a number of errors in the FTT decision is such as to say we don't think this is a conclusion the tribunal.
Very unlikely that you'd say that adding together errors under ground 1, 2, and 3, which wouldn't get you home, could get you home cumulatively. I mean that's not one of these cases.
It is there for completeness. It's not going to add to the length of the hearing. And frankly, I suspect if the court took the view that the conclusion wasn't rational, it would be entitled to set it aside in any event. So query whether it's necessary to have ground 5. It is as I say there as a matter of completeness.
On the I think
point of principle.
Point
yes,
of principle where we've been.
It's ground 1 and it's ground 2 in particular. The point about profit as purpose. Sorry, my lady.
Yes. Yeah, I think we don't need to hear argument on important point of principle. On the timing point,
the procedural point.
The procedural point, the extension of time. You will appreciate, my attention hadn't been drawn to that additional letter. We haven't actually discussed that, but I don't think that's going to detain us.
Great.
As far as the length of the skeleton goes, if you get permission, you're going to have to, first of all, redraft your grounds, and second, your skeleton will undergo some surgery.
It will inevitably be shorter because the point of principle section goes and ground 4 would go.
Right, so it may be, but in any event, this is not the case that you need more than 25 pages.
No.
I mean, your skeleton will probably benefit from being cut because it will be a little clearer.
Always, it would benefit. If I could give an excuse from our perspective, it was a case of not having time to make it shorter because we did find out about it in the middle of August when we were both away. So I'm sure that.
Strange enough, in Lehmans Waterfall 1, I was told twice by the Court of Appeal that my longer skeleton should be cut to 25 pages, and it took about a week to get it down, but it was a better document at the end of the day.
I am certain that it would.
I still lost, but the Supreme Court stepped in on that one.
No,
but
we would certainly do. I mean, as my lord says, there would be surgery required, but also I think we can refine it. Equally, I think having the summary of the facts there in one place is useful because it means you don't have to wade through the FTT and the court.
Right. Well, what we need to do is to consider what we want to do. I think we'll rise just for a few moments, if that's all right, and then we'll come back with and tell you what we propose to do.
Court rise if able.
And say, are they taking advantage? I think that's right. And actually, they're obviously not convinced. Yeah, but actually, I think that helps. Yeah. Daughters of Snow. He's a very nice guy. And he obviously he did insolvency, and that was his main back, so he'll know all about them. They obviously don't love our argument. And I got the sense that they do.
One second, let's talk about him.
Let's see. I think we're going to find out in about 3 seconds. But yeah, I mean, we'll see. Dave, we will have to. Yeah.
That's the point of being law. They're inferring that for that purpose.
Yeah, I think that's very interesting, to be honest. But it makes the point that actually, I think, subject to, I mean, obviously, we get the machine, we don't. I think dropping single actually, potentially, in the main hearing is helpful. Because what it does is let's just say, it flushes out the fact that we're not saying, look at this transaction, was it abusive? It's saying, you look at each party from their perspective, was it a main purpose to obtain the benefit or not? And we don't need to rely on Sickles' motivations. Purposes are irrelevant. In a future case, it might well be that Sickle is the person in the position of Sickle is the key. Yeah. I hope all they were actually like streaming out.
So ask if they can hear it.
A friendly hostile and actually, and also the Sickle point protects us on because the Sickle can sell that's true. Whereas, I mean, well, it doesn't totally make sense because obviously the buyer in the bond market would need to just buy their purpose. Exactly. So it doesn't concern. It will change it. Query the situation. Well, it's back to the situation where they don't know they're buying from an arbitrary. Yeah, it might be great, but it wouldn't. But I think it would. A buyer in the bond market doing so. But I think our answer to that is so. But I don't think this case necessarily. No, I agree. But in general, well, if we won in this case, no, I see. Yes. No, but I mean.
It should have been much worse.
It does mean the buyers in the market otherwise appreciate. And so they shut their eyes. So where you probably get to is that they do need to do some kind of KYC type thing to yeah. And what it stops is this kind of
Court rise if able.
Right. We will give you a written statement or an order and statement of reasons, but we will allow the appeal to proceed on grounds 1, 2, and 3, not 4 and not 5. You will therefore need to comply with the directions which will come out in the order for filing revised grounds of appeal and a revised skeleton argument in support of the appeal, limited to 25 pages. We think that this appeal shouldn't be listed for just one day. That's not an invitation to the parties to expand submissions to fill the available space, but we think it does contain a number of important points, which it would be unfortunate if people felt they had to compress submissions to fit one day. So our proposal is that we will direct that it be listed for a day and a half. And obviously your opponents will be able to form a view as to whether they think that with the reduced grounds, a day and a half is either too much or too little. But I say we don't think it should be compressed into just one day.
I'm extremely grateful for that, my lord. That's very helpful. I might just.
And when we say raises important points, it's important that it reflects the fact that what the potential knock-on consequences are, because you've on a number of occasions said the sole reason or sole purpose in this case, whereas of course the provision is not limited in that way.
If I might flag one thing, which is that I'm conscious in the Upper Tribunal there was a respondent's notice about that there is this issue that HMRC have succeeded on as to whether or not Article 12.5 is limited to situations involving artificial transactions. I would suggest if, obviously entirely open to the other side to put that in, there are quite a few things to say on that. So if the respondent's notice is put in, I might suggest if the court's comfortable with 1.5 days, 1.5 days, 2 days would probably be more suitable in that situation.
Right, well, obviously that will happen when it does.
Of course,
but one way that is sometimes approached is by giving an indication.
Yeah, we can simply say, yeah, I mean, we if it's already been flagged that there may be a respondent's notice, we'll just say 1.5 days to if a respondent's notice is served.
I don't know whether they're intending to, but just given
the reality is that the way the current Court of Appeal is listed, if you say 1.5 days, I think you'd be very surprised. We'd be all very surprised to find that any members of the panel would suddenly be given another half-day appeal on the second afternoon. So in truth, you would get your 2 days anyway, but we can make it, I think, clear enough in our listing directions.
And yes, listing directions, there's always time estimates anyway, so there's a good reason to change it.
Good. Is there anything else that you think we need to deal with today?
No, my lord.
No. Good. All right. Well, thank you very much indeed. So you'll get a.
You don't need us to do anything in relation to the order.
No, we'll do an order.
We'll do an order.
Great.
Good. Good. Thank you very much, and thank you to those behind you and alongside you.
Court rise if able.